how important this issue, again, certiorari being granted in this immunity case is for President Trump, and how it, again, it sets back Jack Smith. I mean, Axios, at least being honest, the Supreme Court hands Trump a huge win before it even hears his case. And you can walk through that as, it's just 2 paragraphs, but it really gets to a couple things. One, of course, there's no stay because you don't need a stay because nothing is going to happen in this case at all. So let's start with that for people, and then call us with your questions, 1-800-684-3110. Remember, this is the case where it was about obstructing acts of Congress, all of that. It was,
which is also at the Supreme
everything
Court right
up
now.
to the line of, it was not, they did not bring a charge of insurrection. I always want to make that clear. But there are, someone is already challenging at the U.S. Supreme Court one of the charges here.
Which are 2 counts for President Trump.
Yeah.
So let me break it down. Let's start with the first sentence.
Yep.
You read it, so I'll preserve my voice.
Yep.
Just go first sentence, and then I'll explain it.
Okay, so it says, the application for a stay presented to the Chief Justice is referred to him by him to the court.
Okay. So normally you get that order, Jordan, and our audience, within 24 hours of when you file the application for a stay. That did not happen here. They stopped. They did not. There was no evidence, at least on the record, that the court keeps where it says refer to the court for a stay. There was no indication that happened. I said on the broadcast, I think Wednesday or Tuesday, that I expected that did happen. So we now know that the application, because the Chief Justice on his own could have dealt with the stay, but he referred it to the court. So that meant all 9 justices got the stay application. Okay, next sentence.
All right. The special counsel's request to treat the stay application as a petition for writ of certiorari is granted, and that petition is granted limited to the following question.
Don't do the question yet. So this was interesting. Remember, Jack Smith in December tried to jump over the Court of Appeals.
Yeah.
Supreme Court said no. Then the Court of Appeals ruled, and then Trump's people took it up as a stay, not a certiorari petition. Just they wanted it stopped, and they were going to file the certiorari petition. Jack Smith said in his response, well, at least treat the stay as a cert petition, which is not an unusual practice. They did that. So the court then, it takes 4 justices to grant a stay, to grant a certiorari petition. There were at least 4 votes at that point to hear it. But then the next sentence says the petition is granted limited to the following question, and I'll let you read in a minute. That question was drafted by the Supreme Court, not the parties.
Right.
So normally, like here, and I'm holding up our red brief, and we're counsel of record for the Colorado GOP on the merits in the case involving disqualification, 14th Amendment. We had in there a question presented. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? That's the question presented that the parties put together. This one, the court drafted. Now go ahead and read it.
So
and we're going to break this down. This is very important.
And then again, so we're going to break it down for you, but let's just read the single question presented. Whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office?
All right, this is very important. So the court drafts the question. First thing they say is the question is whether, so in other words, is there, and if so, to what extent. You got to focus on the, and if so, to what extent. That indicates to me that a number of members, may not be a majority, I don't know that, but a number of members of the court thinks there is immunity. Right. Now the question is whether there is immunity, but also what is the extent of that immunity? And does a former president, this was the thing I said the D.C. Court of Appeals got wrong, enjoy that presidential immunity for official acts during his tenure? The answer to that has to be yes. Because if it's not yes, it means that any president could be brought up by any U.S. attorney on former president on criminal charges. So we just had Mike Pompeo on. You're talking about a senior advisor to the president, right? I mean, he was the Secretary of State. Or how about us? Counsel to the president.
Yeah. And
we're giving advice. And we say, no, this doesn't violate 18 U.S.C., whatever the code section is. That's a criminal code. Well, under this rule, under the D.C. Circuit, at 1201, he became Citizen Trump. Fact is, he doesn't become Citizen Trump. Still a former president of the United States. Is President Bush going to be sued or criminally because there were no weapons of mass destruction? Or how about, President Obama? I could go through all of them. So I think the court got that wrong, but the way they drafted the question, whether and if so, to what extent does the former president enjoy this immunity for official acts? So here's the real question. Did the district court develop a record on whether these were official acts or not? And the answer to that is no, they did not. So that's where I think this ends up going back down. That's why I don't think this case goes to trial, even if he lost this year. And I don't think he's going to lose. Go ahead.
So, I mean, you think, again, that they end up sending it back to decide what
I think they're going to say there is immunity. Right. Now you got to determine, are these official acts?
What you're saying were criminal.
And on the election issues, which is what the January 6th stuff is, I would say that goes under the execution clause of the United States. The president, as commander-in-chief, has to faithfully execute the laws of the United States. He thought they were not faithfully executed. Next line.
Yep. Okay. So
this is important, too.
Without expressing a view on the merits, this court directs the Court of Appeals to continue withholding issuance of the mandate until the sending down of the judgment of this court. The application for a stay is dismissed as moot.
Okay. So they decided we don't need an application for a stay, because we're hearing the case. That meant there were 5 votes to say no mandates issued. What does that mean? When they say without expressing a view on the merits, they're not making a merits decision whether it was criminal act or not a criminal act. They're making a legal determination. That's what the court's going to do as to, does the immunity apply, and what is the extent of that immunity, and does it apply, and this only if in the case of official acts. The district court's going to have to make the determination whether these were official acts or not. The interesting thing is, the mandate, the court froze the Court of Appeals and the district court. Nothing can proceed in these lower courts while this is pending. So the case is stopped. No discovery, no motion practice, no witness exchanges, no evidence exchanges. The case is frozen. It's not going to be, the next sentence talks about, argument is going to be the week of April 22nd. Which is the last week that they hear oral arguments. They didn't expedite this like they did in Colorado. Colorado, they had that argument, remember, on February 8th. I mean, it moved in record time. Here, they're not doing that. It's still the last week of the term. So we've got to file our brief on March 19th, which our team's already working on. But what it means is there's likely not a decision in this case until the end of June, the 1st of July. So the idea that there would be a trial in August or September is not going to happen. I mean, I don't think Judge Shunkin would even do it. I just don't think she would do it.
Even the liberals, Eli Honig said this today, a bite 22.
This is clearly a big win for Donald Trump and a major setback for Jack Smith. In terms of what I think is the big question on people's mind, is there any chance now that this case gets tried before the election? I think my answer is there is the slightest sliver of a chance, but no more than that.
No way. Here's why. The motion practice coming out of this opinion, remember what happened when we did let's talk about our experience. We did 3 cases for President Trump at the Supreme Court on issues similar. It was document requests and temporary presidential immunity. And even though in the DA case, the court said it didn't require heightened scrutiny, the court then said, though, that the president, 9-0, they said this, has the authority to go into federal court, challenge these constitutionally, and can assert that it's interfering with his function as president. Do you know how long it took Jordan to get that resolved later? Another year.
Right.
To get it all the way through the system. Then we delivered the tax returns. What did you hear about the tax returns? Nothing. But the point is, the way this works, there's no way this case can go to trial. Their sliver of hope is 0.
Right. I mean, and that's because...
First of all, if they did it, if they said we're going to go to trial in October while the man's running for president of the United States, a Republican nominee, you'd have a revolt in this country. You can't do that.
Joe Biden would want it either. I
don't think he would either.
That helps President. It actually would help.
Joe Biden needs to be thinking.
Trump.
You know what Joe Biden needs to do? Call Merrick Garland and say, "Hey, your position is going to impact me and my administration.
Especially when I got my son having to testify, my whole family having to testify. You got a special counsel on me, and now if he beats me, what are they going to do to me?
Exactly.
My family.
This is a terrible precedent for any president of the United States. And at the ACLJ, we have been very protective of the executive branch of government and the separation of powers. And I'm telling our audience right now, we've got a team that has represented this president before, putting together an amicus brief filed by the American Center for Law and Justice, letting the court know our view on this, and we've got the experience to back it up.